So thank you very much, all of you, for being here this morning. My name is Ambreena Manji, and I'm based here in Cardiff in the law school, and I've been asked to open this meeting and to say a little bit about gender rules and our plans for this theme at Cardiff. And I want to start, and I think this is really important, by sending congratulations, sororal congratulations, to three remarkable scholars who have conceived of and steered this initiative. They are Sharon Thompson, Lydia Hayes and Dan Newman, who are all here today and who you all know, who have very early in their own careers established really solid reputations for the excellence of their own scholarship. But beyond that, their contribution to this kind of collective effort, to making it possible for us to sit down and think together, will, I think, be a lasting contribution to the life of Cardiff Law School. Can I say just a little bit first about the roots of this initiative in the law school? The idea for a collective such as this that reflects on issues of gender is in what we're calling in the law school a critical friend process that we initiated during the course of this academic year. So as head of the Equality and Diversity Committee of the law school, I agreed to take forward an initiative that John Harrington, as Director of Research, had initiated following the last REF. He sought support from the college to help us to do some work on gender equality in the law school along a number of different axes. And one of the ideas that arose from that appointment of a critical friend was to constitute ourselves as a visible research cluster and to sit together and work together and have opportunities for collaboration, but also for testing ideas out as a group. Now, I've been asked to say a few opening remarks about the theme of this workshop and to reflect briefly on what gender rules might mean for me. And I think the first thing to say is that the theme was conceived to give us a very broad canvas so that we all approach the theme from different places. For me, it would be difficult to talk about gender rules without invoking this woman here, an icon of my East African childhood and a counter in many ways to the message of political quietism that was demanded of us as in East Africa as a minority ethnic group. So I grew up in Kenya, but constantly evoked for us was the expulsion of Asians by Idi Amin from Uganda in the late 1970s. And very dominant in my childhood was a political quietism that refused to acknowledge the role of political engagement, particularly by women such as this, and I'll tell you about her in a minute. And to me, she stood very much as a counter to that, and it's a counter to the dominant narrative, which we also had very much in the late 70s and 80s, of entrepreneurial, politically quietist British Asians, which I think has been supplemented more recently by a deeply problematic racial discourse around Asian men. Anyway, I'm just putting Jayaben Desai up here as, if you like, an icon for me of what gender rules might mean, how we might begin to think about them. Does anybody recognize Jayaben Desai? So Jayaben Desai was the formidable leader of the Brunswick strike. She was part of what was described problematically, but anyway, as strikers in saris. So who defied stereotyping in a way that I think was hugely inspiring to some of us as we were growing up, and I'll return to her in a minute. So to explore just a very small part of this broad canvas of gender rules this morning, at the first meeting of our gender rules group, when we were getting to speak about our research really for the first time as a group and to talk to each other about what our particular research interests were, I asked colleagues, by way of trying to bring out what it was that was particularly feminist about their research, I asked them, so what brought you to feminism? And I now think, actually, on reflection, that I had that question the wrong way round. And I'm reminded of a story that's often attributed to Gandhi when he was asked, why did you come to Europe? And he replied, no, sir, you've got that wrong. You're quite mistaken. Europe came to us. And in the same way, in our individual biographies, and collectively, each of us could tell a story about how it is that we came to feminism. Feminism came to us. I think that one of the signal achievements of feminism in the academy has been to reveal just how partial has been the story of law. So that feminist perspectives on core areas of the curriculum have radically shifted the ground in recent years. And I think we would do well to remember that it's precisely the much maligned metrics and the RAF that in fact perversely has strengthened feminist scholarship and brought it to the centre of the legal academy. Feminist and queer and socio-legal scholarship struggled for so long to find its place in the academy. It was deprecated for its contribution to legal science, but it's now found a central place in many law schools' RAF narratives. So for my part, I think the story of that change and how it was achieved, and those who achieved it, and I may be wrong in this, but my sense is that that story is really still untold. How that ground was shifted is an important story to tell. So that now, in relation to teaching, for example, we're not short of materials with which to insert feminism into our core subjects. The Feminist Judgments Project remains a key example and resource, and more recently, feminist biography has sought to recover submerged narratives about women's contributions to the legal world. But I think that we're still only telling a partial story. And the reason I say this is that the African Studies movement, which forms a significant part of my scholarly identity, is only just beginning to grapple with similar issues. And so I've had time recently to try and reflect on the parallels that we could draw between feminists' achievement in the academy and the ground that still needs to be made up by African Studies. So in recent months I've been thinking a lot, speaking a lot at invited lectures about what African Studies might learn from the signal achievements of feminist legal scientists, and what lessons it might learn for countering marginalization. This is often described as finding the African in African Studies again. So very much at the moment in African Studies, a really difficult debate about the dominance of the Western Academy in African Studies, the lack of African voices in African scholarship, the lack of publication by African scholars in, for example, UK's leading African journals, the role of UK African Studies academics as gatekeepers to journal publishing, and the effect that that has in shaping African studies. All of those debates are difficult debates that we're currently having, and which I suspect are set to grow, and which need, I think, to be confronted. But I raise the issue of the debates in African studies by way of trying to point to what I think are still the limits of our discussions about intersectionality. So we talk about intersectionality to mean attention to intersecting inequalities of race and gender, for example. But I don't think that we've quite reached the point of looking at our scholarship and our curricula and taking intersectionality beyond the individual biography to the structural conditions of law. Now again, I may be wrong on this, but it's my sense that we tell still a partial story of law's origins and its oppressions, and also its potential as a tool against injustice. So to draw on my own area of expertise, land law, we tell a story in which history begins in 1925, the Land Registration Act, We have a teleological account in which we stress 1925, followed by 2002, etc. And we present what I think is a rather prim account of land law, which celebrates private property and strains to keep at a distance the common, the public, and the rustic. Neither will we speak about land law's racial contract, so that we don't say enough, I think, about how dispossession is at the root of land law, as anyone who knows the history of Petty's project for the Survey of Ireland will tell us. In other words, we don't need to go overseas to teach our students about dispossession. But I don't think that it's central to the way in which we teach still our core subjects. And so not to teach the students this is to tell really a partial story in precisely the way that feminist scholarship has resisted. And it's to confirm, I think, a deeply Tory view of landscape and of law. And I want to, at this point, return to Jaya Ben. And here we have a presumptively docile East African Asian woman who refuses the gender rules set out by her white employer. So the dispute arose because the white owners of the film processing plant in North London refused to allow the workers to be unionised, and assumed that because the majority of these workers were Asian women from East Africa, that they would be grateful for their jobs, they would be undemanding, non-unionised workers. And the pictures, I mean, I don't know, this beautiful footage available of Jaya Ben in her sari on the picket line. And there's particularly beautiful footage of miners and postal workers, white workers, coming out in support of the strike that she led. Particularly for me, miners from South Wales bussing into North London to support her on the strike. So you get these beautiful shots of these big burly miners and this really quite diminutive woman in her sari. So much then for the docile Asian woman, so much for the attempt to divide workers amongst themselves and to stoke white workers' discontent against immigrants. And so to end, another set of images. This woman, a student leader of South Africa's Fees Must Fall movement, which evolved, I suppose, developed into its Roads Must Fall movement. Here invoking South Africa's incomplete decolonisation. So she was a student leader at Cape Town and was determined that feminist students be heard in the movement, in a movement that was very much dominated at its start by male students. She became known as the blade in the spear. On the contrary, Wasizwe is the armed wing of the ANC, the spear, and she was heralded during this period, not long ago now, as the sword, the blade in the spear. And to me, she is a reminder, more recently, to be sceptical of accounts of student passivity in the present day. Students, I think, come to law school in part because they're interested in injustice. Our Global Justice Pro Bono program in the law school, which ran, some of you know, for the first time as a pilot this year, gave us critical insights into just how dissatisfied students might be with a framework in which we tell them plenty of law, but don't tell them anything about injustice. So during this year, we've partnered with a human rights law firm, Dayton Pierce Glynn, and with Amnesty International in both Nairobi and London, to work with students to prepare a case for judicial review of an EU lending decision for aid which is leading to evictions and clearance of a slum, an informal settlement in Nairobi. And under the guidance of the Hingorani Foundation, which is based in Delhi, which advises and advocates for public interest litigation, we've worked with these students to develop what we think is a very solid case for judicial review, and we're waiting now for instructions from Amnesty in Nairobi, particularly about whether they're comfortable with us taking steps to bring this case for judicial review. And that's interesting in itself, because the politics about whether or not to push the judicial review line, whether or not that's the right thing to do strategically, is a conversation the students are finding really fascinating, because clearly we have a very strong legal case, but the politics about whether Amnesty want to push it in this particular direction is a completely different story. We've also learned, and I'm happy to mention this, that we now have a new case to work on with our students next year. We've just been asked to take on a very interesting case with our new cohort of undergraduates in relation to Tanzania. So we're hugely excited about the fact that we're developing this global justice expertise on East Africa in the law school. So in any case, enough from me for now. It really just remains for me, having tried to set the scene essentially by making a few connected, not necessarily coherent suggestions. It just remains for me to say that as we think about gender rules today, I wish us all a radically unruly meeting.